Hi, I'm James Lowe. A lot of times people call our firm because we have a national reputation in representing people who've been catastrophically injured or the families of people who have been killed in automobile collisions of one kind or another. Sometimes the seat fails, sometimes the fuel system fails and causes a fire, sometimes the airbags don't deploy when they should, all manner of cases like that. And when people call us, they sometimes recognize that they too were at least partially at fault for causing the underlying collision, which resulted in their injuries. And they wonder if they're partially at fault for their injuries, can they still pursue an auto product liability case because the vehicle itself was defective and unreasonably dangerous? And the answer to that is, in Ohio, for sure, the answer is yes. The issue is whether or not your own conduct or the driver's own conduct was more responsible for their injury or death than the fault of the auto manufacturer's design. So in most cases, it is really the design of the vehicle that caused the injuries. Yes, the individual may have caused the accident, but the injuries, or the catastrophically horrible quadriplegia or burn injuries, were caused because of the defective design of the automobile. So that really makes it pretty easy for people in Ohio. In some states, there are rules that say if you are even a tiny bit responsible for your own injuries, you can't pursue certain kinds of cases, negligence case or a strict liability case. That's called pure contributory negligence. And those are pretty tough cases, but there are other ways to pursue those cases. And people do those cases regularly in those states. They're not intimidated by those rules. So the answer is, if you think that your injuries or the death of a family member or a close friend was caused at least in part by something wrong with the car itself or the truck itself, feel free to give us a call anytime. We're always here to help you. Thanks a lot.